Hey everybody, it's Andy and welcome again to my office in Modesto, California. If you're new to the channel, I'm an attorney licensed to practice law in California as well as New York. In this video, I'm going to try to go over bench warrants in California criminal court. We'll see how this goes because the topic of bench warrants can be a little bit confusing is not the right word, but there's a lot to it basically. So bench warrants are actually quite common, and I've actually run into quite a few people, clients and otherwise, who basically have bench warrants that they know they have one, but they're too afraid basically to take care of it because they're worried about going to jail, for example. So this video, if you're in a situation like that, hopefully this video basically helps you out. So I'm going to start the video by going over what a bench warrant is, how you get one. So a warrant, a bench warrant, if I am to paraphrase it myself, a bench warrant basically is a command from a judge to find this person, this particular defendant in a criminal case, let's say, and bring them before the court because they failed to show up when they were supposed to. So if you have a court case in California, a felony or a misdemeanor, let's say, and you're not actually in custody, like you're not in jail awaiting, awaiting trial, let's say that you bailed out or you're on OR release, own recognizance release, you generally speaking will have several court dates that you have to show up at. A while back, I put out a video that goes over various things you can do in California to be successful in your criminal court case. So one of the things that I mentioned was, okay, show up to court when you're supposed to, because if you, because it's really easy to do, first of all, but if you don't, then you have a bench warrant that goes out against you and it makes your case much more complicated, blah, blah, blah. So showing up for court is basically one thing that is really easy to do that basically reduces the chance of you getting a bench warrant by quite a bit. So that's one thing that you can do to prevent yourself to get from getting a bench warrant. But generally speaking, I would say a bench warrant is something where law enforcement is commanded to basically go out and find you and bring you before the court because you failed to show up. So technically that's probably the definition, I think, but realistically is law enforcement going to go out and purposely try to find you? In some cases, maybe, but I think in most cases, just the manpower involved, like the personnel, the budget, and all that stuff involved, probably is too much. So what typically happens, or at least the cases that I've seen and dealt with, typically what happens is that a defendant doesn't show up for criminal court, let's say, when they're supposed to. They forgot about it, they're on the run, something. So when judges issue bench warrants, they don't know the reason why you didn't show up. It could be innocent. It could be not so innocent. But they will issue you a bench warrant just because you didn't show up. So anyway, what typically happens about bench warrants is that law enforcement does not affirmatively go out to try to hunt you down. Sometimes they might, but most of the time they just don't have the resources to do it. What typically happens, however, is that you have a bench warrant out because you didn't show up. Maybe you know that you didn't show up. Maybe you didn't know. Maybe you honestly just have no idea. But you commit an offense of some kind. Typically, it's something pretty silly, like you're speeding, using your cell phone when you're driving, you run a stop sign, you run a red light, tailgating, something like that. So, something like that where law enforcement will pull you over because it's really easy for them. Like it's a simple kind of slam dunk, ticket, I guess they can give you. But in the course of writing you that ticket, they check your ID, they make sure you have insurance, registration, all that stuff. And in the course of checking your ID, they run your name to go, whoa, hey, Mr. Jones, you actually have a bench warrant now, $25,000 from the next county over. Looks like you forgot to show up for court one day. Oh, okay. So what happens, well, I guess most of the time, not all the time now, but what happens most of the time though is that if you have like a ticket, something ticketable, I guess citable, I guess that's probably a better word. If you have something that's citable, like a stop sign violation, the cop writes you the citation and then you can leave. If you have a warrant, however, generally speaking, the officer basically will not, let you leave. The officer will arrest you, even though the initial thing that they stopped you for is just a citation. So that's what the bench warrant does. It transforms the citation into an arrest. Not all the time. Like sometimes when the bench warrant's really small, for example, in terms of dollar value, the officer might go, hey, I don't have the reason, or my agency, my department doesn't have the resources to book you, to put you out on bail, to arrest you and so forth. Tell you what, I'm going to cite you and release you. I'm going to give you a court date. You just have to show up for court on that date. If you don't, you'll get another bench warrant, blah, blah. So cited release is a possibility, depending on the county, the amount of the warrant, etc. But usually, getting caught with a bench warrant usually happens, when you have like a traffic offense of some kind, and that usually transforms the citation, the traffic citation, into a full-fledged arrest where you're actually, thrown in jail for the night, let's say. So, if you are actually thrown in jail, because of that, what typically happens is that, the dollar value of the warrant, like if you post that, like if you put up $40,000, let's say, for a $40,000 bench warrant, you can make bail on that. If you're wanted for other things, however, you might not, be entitled to bail. Like if you're wanted out of another state or another country or something, you might not get bail that way. Like the law enforcement wants to keep you actually in custody. But generally speaking, if you have a warrant for, say, $25,000 or $50,000, that's the bail amount. So, basically put that up, and, generally speaking, you can get out on bail within a few days, let's say. But obviously, if you're arrested, without kind of, any kind of warning, you might be out of commission, I guess. You might be in jail for, like, say, 3 days or 4 days while the bail gets handled, while the judge, signs off and orders your release, blah, blah, blah. So if you have like children that you have to take care of, if you have a job that you have to go to, getting arrested and suddenly disappearing for 3 or 4 days can be really like not helpful for you, I guess. Like you could lose your job, let's say. So like, I guess to me, that would be one reason to take care of a bench warrant quickly, because, randomly being arrested, I guess, being arrested at random for several days and being kind of out of commission, generally speaking, is not going to be real helpful for whatever kind of goals that you want to accomplish. So that's what a bench warrant is, and that basically is what happens when you get caught on a bench warrant. You generally will be arrested versus just cited and let go. Sometimes you can be cited and let go if you have a warrant, but usually not. So the next question that I get a lot basically is, how do I take care of a bench warrant? The good news, I guess, is that it's actually really easy to take care of a bench warrant, to get it recalled. Recalling a bench warrant is the term, so I'll write that up here. Recalling a bench warrant. It's actually really easy to do. Number one is what you want to do is let me start that again. Recalling a bench warrant actually is really easy to do. You want to get it recalled quickly, so within a few days at best. Don't wait a year, 6 months, etc. Acting quickly sooner versus later actually is really helpful when it comes to getting a bench warrant recalled. The bad news, however, is that recalling a bench warrant, it unfortunately varies. The process varies from county to county in California. I'll go over two of the most common processes that I encounter. If you're elsewhere in California, I have no idea what process applies in your county. If you have a different process other than the ones I described in California, leave me a comment down below describing the process, how it works, etc. And if you are especially in another state or country, leave me a comment down below also about how the warrant recall process in your city, in your state, country, etc. works. So number one, the kind of guiding rule here is that if you want to recall a bench warrant, do it sooner versus later. Promptness actually is really helpful. Most judges, I want to say, will kind of acknowledge, like, I'm sure they're not happy about it, but they will acknowledge that people do make mistakes, they forget, they're doing their best, but not everybody is familiar with how court works. So promptness, diligence, can be really helpful in convincing a judge that you really didn't mean it. So the two most common ways in which I see bench warrants being recalled, the first way basically is to fill out a form, like a local form typically, like a form that's only used in that county. Fill out a form asking to be put back on the judge's calendar to basically to arrange for a date to actually go in front of the judge. Once you arrange for a hearing date, then you go in front of the judge, ask for the warrant to be recalled, the judge does it, and that's how the warrant's taken care of. So the way it works in Santa Clara County, for example, in California, is there is a form that you fill out. You ask to get in front of this judge on this case number, and for the reason you say, the defendant has a bench warrant. I would like to, to get in front of the judge to please have the warrant recalled. I just forgot about the court date. I'm really sorry. The judge will look that over and sign off on it and tell you, okay, take this down to the clerk's office, and they'll give you a court date, and we'll see you on that court date. Make sure you show up. So you show up on that court date, you ask the judge to recall the warrant, and that's basically how it's handled. You literally basically just say, Your Honor, thank you for allowing me to be here today. I have a bench warrant. I forgot to show up on blah, blah, blah date. I'm really sorry. I put it down on my calendar wrong. Could you please recall that bench warrant? I'd like to move forward with my case, please. So if you show humility, like proper humility, you try to take responsibility, and you act promptly, judges typically will kind of view those as positive things. Obviously, if you show up late, you don't show up at all, you try to place blame on others and so forth, you appear arrogant, blah, blah. Generally speaking, those are not going to be helpful for your case. Yeah. So option number one is that you have to fill out a form, submit the form for approval to the court. The court gives you a date. You show up maybe 10 days later or something. So Santa Clara County in California does it that way. The second way that I've seen actually is how San Mateo County in California does it. So if you don't know, San Mateo County and Santa Clara County are adjacent to one another. San Mateo County rather is basically the county to the northwest. Yeah. So the way that San Mateo County does it is you can basically walk up to the counter, at the courthouse, the morning of. So if you have a warrant, basically between 8 and 8:15 in the morning, most weekdays, you can go to the courthouse and just say, I think I have a bench warrant out. I'd like to get in front of a judge today to please get that recalled and taken care of. I'd like to, move on with my case, please. Generally speaking, the court will verify that you actually do have a bench warrant. And if you do and you show up at the right times, you can generally get in front of a judge by 8:30 that morning, so within 20 minutes, versus say 10 days later, for example. So another thing I guess you should probably do is you should verify that you actually have a warrant out. So if you, I guess you can always go to the courthouse, I think, and they'll probably be able to look it up for you. A lot of counties rather in California will put case information online. You might be able to go online, type in your name and stuff and search that way. If you missed a court date and you missed a court date, generally speaking, I would assume that you have a warrant, even though you can't confirm that in some way. But so that's basically the recall practice. You have to find out what your county's procedures are, but once you do that, you go, you ask to be put on calendar, or you appear in front of a judge, you apologize, you say that you'd like to move on with your case, blah, blah. Generally speaking, the judge will be fairly accommodating that way, at least the first time. If you repeatedly don't show up for court, get warrants and get bench warrants and stuff, the more times that happens, the judge will go hey, what's going on? Why are you not showing up for court? Yeah. So basically, if you are, if you do have a bench warrant, to get it recalled actually is fairly simple, but the process in each county varies. You have to get back in front of the judge somehow. You have to arrange a day and a time for a court hearing. But once that happens, if you've acted promptly, you take responsibility. Sometimes all you literally need to say is, Your Honor, I'm sorry, I'd like to move on with my case, please. I promise to show up at all future court dates. Could you please recall the bench warrant? And a lot of times that's all that's required. So the next question that I get a lot basically is, Andy, hey, I know I have a bench warrant. I know that I missed court, but I'm really scared. I don't want to go to jail because I got kids I got to take care of. I got a job. I can't miss work. I really want to take care of my bench warrant, but I'm really afraid that the judge will throw me in jail. What do I do? So there is unfortunately no easy answer to that question. So can the judge throw you in jail? I won't lie to you guys here. Yes. There is a possibility, depending on the facts of your case, depending on how strict the judge is, depending on how strict the prosecutor is, for example. Can you in the process of getting your warrant recalled, can you be thrown in jail? Yes. Whether or not you can make bail, that's a different question. Hopefully you can, but bail, even if it's $25,000 or something, you're looking at putting up $2,500 to a bail bonds place, let's say. So I guess I want to make clear at the beginning, can you be thrown in jail when you try to get a bench warrant recalled? Possibly. What are the odds that actually will happen? I would say fairly low. It depends on the facts of your case, obviously. So if this is your third or fourth bench warrant for failing to appear, that's different. But generally speaking, judges, for example, they understand how much room the county jail has, for instance. So if you just basically didn't show up for a DUI, court date, and you honestly forgot, and it's your first offense and you have no other criminal background, the judge is most likely not going to want to throw you in jail because you're, like, in terms of fish, quote unquote, you're a small fish. In the limited jail space they have to keep for like more serious, kind of criminals, like people who have cases that are more serious, that, people are at risk, if that criminal is not put into the jail, for example. So in terms of, I guess, how big of a fish you are, if you're a small fish, judges generally kind of realize, hey, small fishes, I would love to put them in jail, but I can't because I know how much space there is in the jail. So, I have no choice but to let them out again, or to just let them, to not put them in jail in the first place. So that's one kind of thought that I would have. Most of the time, like the vast majority of judges, let's put it that way, the vast majority of judges recognize things about, hey, people have jobs, they can't miss work, they're doing the best they can, they have kids that they have to, take care of, and so forth. If you, I guess, have like a pretty minor case and it's your first offense, for example, if you kind of plead sufficiently, if you kind of throw yourself on the court's mercy, for example, and say that you have a job that you have to go to, you have rent, you have child support, you have other kids you're taking care of, and so forth. Generally speaking, judges won't want to disrupt that because they kind of realize, hey, when this case, for example, finishes, there's going to be a lot of financial stuff, fines, classes, etc., that they have to pay. None of that is served by, preventing this defendant from working. He's promised to show up, and in the past, he's basically done that. This is his first, failure to do that, and so forth. So I'm going to give him the benefit of the doubt and not put him in jail. A lot of times, I think most judges will do something like that, but I can't tell you for sure, yes, the judge will not throw you in jail, period. I don't think any lawyer can. Unfortunately, it all depends on the judge that you have, the type of case that you have, the history that you have in that case, and so on. So, sorry if that's a bit of a downer, but basically, even with that, I would say take care of your case sooner versus later. Like, take care of it, meaning get your bench warrant recalled, finish your case, take a plea, take it to trial, whatever. So, as an example of that, I'll describe this. So, let's say, for instance, that you have a relatively minor drunk driving case. Like, you got caught, you didn't hit anybody, you didn't kill anybody, it's your first offense, so it's pretty minor. But let's say that you went to one court date, but then you didn't show up for any of the other court dates. You just forgot, like you thought it was done or something. So you get a bench warrant out, and let's say that you have no idea that you have a bench warrant, or maybe you do, but you kind of are really hesitant to take care of it because you don't know if you're going to get thrown in jail. So you figured, hey, I'll just concentrate on not getting caught, everything will be fine. So let's say, for instance, that you basically don't take care of the warrant and you go on and you live your life for like 5 years in a row. For example, like 5 years, everything's fine. One day you just are unlucky and you get pulled over for running a stop sign. Normally the officer would just cite you for it and release you, but because the officer checks your ID, he or she realizes, oh, hey, you have a bench warrant from 5 years ago. Wow, hey, I can't let you go here. Like, I got to arrest you. And like I said, all of a sudden the arrest kind of pops up and it interferes with your job, your kids, etc. Even if you're just in jail for like 2-3 days, let's say, that basically is just a really big disruption. That if you're just taking care of the bench warrant rather sooner versus later, the arrest probably would not have happened. So that's one kind of reason to take care of the bench warrant sooner, like I said. So the other reason here, I don't know if this is policy, amongst prosecutors. I don't know if there's a law specifically requiring this. If, however, you have a bench warrant and you know about it, you don't take care of it for like 5, 6, 8 years or something. One day you just happen to get caught for something else and you get arrested, you get brought back before the judge on that same case that you had from 5, 6 years ago. What I've seen typically happen is that the prosecutor basically looks at that and goes like, hey, you didn't take care of this for 6 years or 5 years or some significant amount of time. And because you didn't do that, that shows to me that you don't treat this seriously. So therefore, my offer to you, if you want to resolve this, is going to be a lot worse than had you just resolved it, quickly, let's say. So, to kind of just make some numbers up, let's say that, if you got a bench warrant and you took care of it right away, the prosecutor goes like, hey, you made a mistake. Okay, it's no big deal. You took care of the bench warrant quickly. That's fine. Tell you what, my offer to resolve this for you is 5 days of jail. You do some work program, let's say, and it's good. However, let's say that you don't take care of your bench warrant right away. You wait 5 years. You get caught on something else. You get back in front of that same prosecutor, and the prosecutor goes like, whoa, hey, this has been hanging out here for 6 years, 5 years, whatever it is. My offer to resolve right now is 100 days of jail, not 5 days of work program. You have to go to jail for 100 days. If you want to take it to trial, that's fine, but if you want to resolve it now, because you waited so long, it's 100 days of jail versus 5 days of work program. So prosecutors a lot of times will look at the fact of how long your bench warrant was out there for, and whether you took care of it on your own, let's say. So hopefully all of that helped. It's a lot of information, but to kind of summarize real quickly, if you have a bench warrant, it's generally speaking because you didn't show up for court when you're supposed to. Show up for court when you're supposed to. It's a really easy thing to do. Don't mess with bench warrants at all. Number two, if you have a bench warrant, what that typically means is that law enforcement, when they catch you, usually in the process of catching you for other things like speeding, stop signs, that kind of thing, they generally will arrest you versus just citing and releasing you. If you get arrested, generally speaking, you can bail out, but that takes some time to kind of arrange. So it is something where you basically will be unable to work for 3 days. You can't take care of your kids for 3 days, something like that. So the way to get a bench warrant taken care of, it's called a recall. So you want to recall a bench warrant. The general rule there is you want to do that as quickly as you can, ideally within like a week or two of the warrant actually being recalled. Don't wait several years, or don't just ignore it hoping that the warrant will expire. Just in my experience, if you wait a long time, generally prosecutors will look at that to go like, oh, hey, you didn't care about this case, you ignored it. I'm going to make my offer for you, or my offer to resolve, a lot worse than it normally would be. And I guess to get a bench warrant recalled, the process in each county unfortunately varies, but hopefully if you go to your county courthouse and kind of say, hey, can you check to see if I have a warrant? I think I might. I'd like to get that taken care of, but I don't know how to do it. Can you help me out? Most courts will try to guide you in the right way to do that. It's better for them if they don't have a lot of warrants kind of pending also. I think that's all that I wanted to say. So that's a lot of information, but hopefully all of that helped. So go ahead and share, like, comment, subscribe, all that stuff, and I will talk to you guys next time. Thanks.